They actually, when I was at district court, and Mike and Cindy got to see my diatribe and treatise on the Constitution to slap the judge into submission, we walked out of there, and the marshals were there. What a lot of you don't know is that I am still considered the number one criminal in the state of Arizona. No, seriously, I am. And they asked them for ID, and they go, and I'm like, you don't want my ID? And they said, no, Mr. Stewart, we know who you are. I'm like, yeah, you're trying to scare me, thanks. But Cindy's done an incredible job finding this stuff. And the reason she's been able to find stuff is she understands the theory. She understands what's really going on. When people ask me certain questions, I know you're not completely getting it. When you get it and you read this stuff and you read the cases, you'll know why you were looking at everything backwards. And you go back and you read through the same court cases, a very important one, Henry Barry Weisband, March 29, 2010, district court here in Arizona, bankruptcy court, which explains the whole process very well. But if you understand that the judge knows the pretext, that the note has nothing to do with the foreclosure, it reads completely different than if you're trying to find out whether the judge is forcing the bank to present the note, because they're not. And remember, it's not a matter of presenting the note, it's a matter of exhibiting the instrument. And that's legalese in the UCC. All right, let's jump on a few things here, because I think we have about 30 minutes before we go to lunch. She's asking if when you do the QWR, should you have the process server serve it? Depending on your financial situation, it may behoove you to have a process server do everything. Hopefully today we'll have a process server stop by to drop off cards. And even if you're out of state, you can contact him because he has connections in other states. These guys are good at getting it to the right people, and that's important. All right, we're going to jump over to page 5 here. There's a lot of arguments. Cindy brought up the one about recorded at the same time. See, they've got to do things in order. I'm not going to get into one of my typical diatribes of how corrupt the court is. Don't have time, and this is going to go over all of the internet. And it's not like they're not lacking in evidence of what an asshole I am. I don't need to give more. But what the court is, what law is, it's a process. It's a set order of rules and guidelines, if it's nothing else. And that goes along with any kind of dealings in real property. Now, because of that, there's a process that they have to follow. They got to do this and they got to do that. Those of you that are familiar with the notarial process, the notarial certificate of dishonor and all this other patriot crap that don't work, you've learned that there's processes, okay? And they can be very cut and dry. They're very rarely ambiguous at all. There's dates, there's, you got to do this, and then this in a certain amount of days, and then this person's default, and this person has to cure. Those are all legal processes. Everybody in any kind of litigation it's incumbent on them to know the process and to follow them. When they want to commence this foreclosure proceeding, whether it's judicial or non-judicial, there's a process they must follow. And it's not do everything at exactly the same time. It's not. You can't do everything at exactly the same time. That in and of itself is evidence of fraud. So the fact that they do everything at the same time is prima facie evidence of some aspect of fraud. We just don't know what. Now, when you talk about fraud in its purely simplest definition in law, it's not incumbent on you to understand, analyze, define, or dictate the fraud in its entirety. You just have to evidence that there was fraud. If you read the RICO Act, Racketeering Influence Corruption Act, that came out over the gangster thing, what was it, 80 years ago. Racketeering was a very common word. We really don't use it anymore. But when they wrote that act in 1927, I think it was, they didn't know what crimes everybody was committing. They just said, all we got to do is just establish is you guys are working together to commit some kind of crime. And that's really how we understand fraud today anyways. So, but I would advise you read that because it spells it out pretty well. We've already discussed that the foreclosure is not a redemption of a promissory note. And due process of law includes maxims of law. When you read the definition of due process of law, now understand there's due process, there's due process of law. It's delineated in the 14th Amendment to the U.S. Constitution. It talks about it in another place, but that's what we're primarily going to use. Well, the due process of law, which means that everybody has to follow certain guidelines and you have certain rights. That is incumbent, and it gives in the definition, you know what? Why don't I read it? This was not only custom made for me, this was my pillow in jail. So it's a little beat up. And the only reason I'm going through the trouble of reading this is so that you understand. Due process of law in each particular case means such an exercise of the powers of government as the settled maxims of law permit and sanction, and under such safeguards for the protection of individual rights as those maxims prescribe for the class of cases to which the one in question belongs. So it mentions maxims of law twice in the definition. Due process of law is incumbent on maxims of law, which relates to the service of process. They will always argue two things. Rule 12b-6, failure to state a claim upon which relief can be granted. You can make your claims just as we do, number them, say these are the claims, and then number your relief requested, and they're going to still pull out Rule 12b-6 and say you failed to state a claim upon which relief can be granted. You just say, well, then, yes, I did. Here, I'll repeat them. But they're also going to fight on service of process. You must do an affidavit. The process server does that. Then for any corresponding communications, you can do an affidavit saying, I served them this way, I mailed this, blah, blah, blah. That stuff's real important because they're always going to fight on that. They're fighting harder on it now because that's the only things they've got to fight us on now. They really can't fight on the concepts of the complaint because it's too obvious. The forensic examinations prove everything that we're saying. So they got to find another way. Patrick, we've got a question coming up here. I'll take that real quick because I want to cover these last 2 points real hard before we go to lunch. Go ahead.
Because I was low on funds, I did not send my complaint by service process to City Mortgage. I did send it by certified mail to the address that I knew. Green card return. Would that be a problem as well?
It it can be a problem for us. You know, that's why we use the legal maxim that any response by them cures the deficiency in the process. And we put that right in the document. I think that's important. The maxim of law says, and SCOTUS has repeatedly decided and stated in its memorandum of decisions that no matter how they got it, if they respond, they got it. So they, yes. Oh, okay. In the CD, yeah, there's a bunch of judicial notices. That spells it out quite well. So that is good enough. Are you going to have an argument? Yes, you are. You better be able to defend it. You're better off to get a process server.
But
you can't always do it.
But the green card signed by them is your proof that they got it. So that's in a sense a response.
No, not at all. It's their response. Anybody can sign a green card. As a matter of fact, most of the time they don't sign it, they stamp it.
Okay, because
And it's usually this Nelson character, and I'm not sure if he even is alive. I'm not sure if there is a Nelson. It's an acknowledgement that they got it. Basically, it doesn't matter if it falls out of an airplane, lands in their pocket. Once they respond, they've admitted they know about the suit. It's knowledge. Yes, if you're going after the corporation, see, we don't go after the corporations. We go after the CEOs. To me, a bank is nothing more than the gun, and the CEO is the mugger. Okay? I'm not suing the gun. I'm suing the mugger. It's a different way of looking at it. I want to have a human being, and I use that term loosely when talking about a banker, but I want to have somebody to bring into court, and I can't bring in a bank. All right, and we can discuss service of process all day. If you can get a process server to do it, it's the best way to do it. Otherwise, you got to evidence that there's no way to serve these people. In my criminal case, the cop that destroyed the evidence and planted evidence and committed perjury and all that, when the process server showed up to him, he grabbed his gun and told him, "You're not serving me," and the process server ran away and called me and said, "Come get these. I'm not screwing with this guy." I'm like, damn. But he's a very, very dirty cop. Okay, look at number 4 and 5. Now, the bank's not holder in due course. Bank's not the creditor. We know that. We all know that. The court doesn't know that. Why does the court not know it? You guys are getting it. So you must rebut it. Now, when we first started this, and we had a girl that had to go to court, and we practiced and practiced, I wish you guys had been there, because this was great. See, the way that courts operate, the first time you say something, they'll kind of blow it off. The second time, they'll kind of take notice. The third time, they better take notice. By the fourth time, if judge doesn't act, then that's prima facie evidence he's in collusion. So I started this whole thing where ask the judge, because you don't accuse anybody in court. Unless you're me, then I accuse the judge of treason, and that's fun. That is, I mean, you really want to get the blood going and watch them just, their head spin and do the exorcist thing. Start calling the judge a treasonous, traded, I won't say those words here. Save those for court. But you get the other side to either refuse or acquiesce. And so we came up with this plan where we just commenced the whole proceeding with, Your Honor, we can settle this matter right here if you just have The bank stipulate on and for the record, are they the creditor, and are they or are they not the holder in due course?